The officer looks at you and asks one simple question.
Where are you coming from tonight?
It sounds harmless. It sounds routine. It sounds like the kind of question anyone would answer without thinking. But what you say in that moment, or what you do not say, could determine whether you walk away free or whether you end up in handcuffs. Police questioning is one of the most legally dangerous situations an ordinary American can face, not because police are always wrong, but because most Americans have no idea what their rights actually are in that moment. And they say things that destroy their own legal defense without realizing it. Today on Rights and Reality USA, this is video 10, the final video in our Criminal Rights Authority series. And we are saving the most important topic for last. We are going to cover exactly what your rights are during police questioning, what you are required to say, what you are never required to say, how to correctly invoke your rights, the mistakes that cost people their freedom, and the one rule that legal experts, defense attorneys, and law professors all agree on that almost nobody follows. Stay until the end, because Chapter 6 covers the single biggest mistake Americans make during police questioning, and it might surprise you. This is not legal advice, but it is legal knowledge. And today, it could save your freedom. Let us get into it. Everything we cover today is built on one foundation, the Fifth Amendment to the United States Constitution. The Fifth Amendment states that no person shall be compelled in any criminal case to be a witness against himself. 6 words define your entire right during police questioning. No person shall be compelled. You cannot be forced. You cannot be legally required. You cannot be ordered to provide information that could be used against you in a criminal proceeding. This is not a technicality. This is not a loophole. This is a fundamental right that the founders of this nation considered so essential to freedom that they wrote it directly into the Constitution. And yet, study after study shows that the vast majority of Americans voluntarily give up this right every single time they speak to police without an attorney present. They do not give it up because they are forced to. They give it up because they do not know they have it, because they think that only guilty people stay silent, because they want to be cooperative, because they believe that talking will help them. All of those beliefs are wrong. Here is the single most important thing you will hear today. We are going to explain exactly why that is true, and exactly what to do instead. Let us answer the most fundamental question first. Are you legally required to answer police questions? The answer is almost never, and the exception is narrower than most people realize. In most states, when police have lawfully stopped you during a traffic stop, or when they have reasonable suspicion that you were involved in criminal activity, you are required to identify yourself. That means providing your name. In some states, it includes your address. In most states, it does not include anything else. That is the full legal extent of what you are required to provide in the vast majority of situations. You are not required to answer questions about where you are going. You are not required to answer questions about where you have been. You are not required to explain your actions or your activities. You are not required to explain why you are in a particular area. You are not required to answer questions about other people. You are not required to consent to any search. Now, there is a critical distinction you must understand. There is a difference between a consensual encounter and a detention. A consensual encounter is when police approach you and begin asking questions, but you are technically free to leave. You are not being detained. In a consensual encounter, you do not even have to provide your name in most states. You can simply walk away. A detention is when police have lawfully stopped you and you are not free to leave. In a detention, you may be required to identify yourself, but you are still not required to answer any other questions. At any point, in any of these situations, you can and should say, "I am choosing to remain silent. I would like to speak with an attorney."
Here is something that surprises most people. Simply staying silent is not enough.
In 2013, the United States Supreme Court ruled in Salinas versus Texas that if a person stays silent without explicitly invoking their Fifth Amendment right, that silence can potentially be used against them in court. What this means practically, you cannot just stop talking and expect to be legally protected. You must say the words.
You must explicitly invoke your right.
Here is the exact phrase. Memorize it.
Say it clearly, say it calmly, say it once.
After you say those words, stop talking completely. Do not explain yourself. Do not justify your silence. Do not make small talk. Do not answer what seem like innocent follow-up questions. Because here is what police are trained to do after you invoke your right. They will keep talking. They will try to keep the conversation going. They may say things like, "You are not under arrest, we just want to get your side of the story." Or, "It will look much better for you if you cooperate now." Or, "We already know what happened. We just want to hear it from you." Do not respond to any of it. Once you have invoked your right to remain silent and your right to an attorney, any statement you make after that point is extremely legally dangerous, because if you begin talking again after invoking your rights, courts may find that you voluntarily re-engaged with police and waived your protection. Say the words, then stay silent. There is nothing else to do. The Sixth Amendment to the United States Constitution gives you the right to have an attorney present during any critical stage of criminal proceedings, including police questioning once you are in custody. But there is an important practical question. What if you cannot afford an attorney? The Supreme Court answered that in Gideon versus Wainwright in 1963. If you cannot afford an attorney, the government must provide one for you at no cost. This is your public defender. Here is how to invoke your right to an attorney correctly. Say these exact words. Once you say those words, police must stop questioning you. This was established by the Supreme Court in Edwards versus Arizona in 1981. Once you invoke your right to counsel, all police questioning must cease until an attorney is present. However, there are two critical points you must understand. First, this rule applies once you are in custody. Before formal arrest and custody, the rules are different and the protection is not automatic. This is one of the most legally complex areas of criminal procedure, which is exactly why the safest approach is to invoke both your right to silence and your right to an attorney the moment any police questioning begins, whether you are in custody or not. Second, invoking your right to an attorney is not a confession. It is not an admission of guilt. It is not suspicious behavior. Every legal expert, every defense attorney, every law professor in America will tell you the same thing. Never speak to police without an attorney present. That is not cynicism. That is the law working exactly as it was designed to work. Police must stop questioning the moment you say, "I want an attorney." This chapter is critical, because knowing your rights is not enough if you do not understand the tactics that may be used to get you to give them up. Police interrogation is a trained skill. Officers receive extensive training in psychological techniques designed to encourage suspects and witnesses to talk. And here is the most important thing you need to know about those tactics. In the United States, police are legally allowed to lie to you during an interrogation. The Supreme Court established this in Frazier versus Cupp in 1969. Officers can tell you, "We have your fingerprints. We have a witness who saw you. Your friend already told us everything. The evidence is overwhelming." None of these things need to be true. The strategy is to make you feel that resistance is pointless, that talking is your only option, that getting your side of the story out now is better than waiting. It is not. Talking without an attorney is never better. Here are the most common interrogation tactics used and how to respond to each one. Tactic 1. The false evidence ploy. Police claim they have evidence against you that does not exist. Your response: say nothing. Invoke your rights. Evidence is for court, not for the roadside or the interrogation room. Tactic 2. The good cop, bad cop routine. One officer is aggressive and accusatory. The other is sympathetic and understanding. The sympathetic officer makes you feel like confiding in them is safe. It is not. Both officers have the same goal. Say nothing to either of them. Tactic 3. The minimization technique. The officer suggests that what you did was understandable, not that serious, an accident, a misunderstanding. They suggest that if you just explain yourself, it will all go away. This is designed to lower your psychological resistance. Do not lower it. Say nothing. Tactic 4. The time pressure technique. The officer suggests that if you do not talk now, things will get much worse. That this is your only chance to help yourself. That the window is closing. This is pressure designed to prevent you from thinking clearly. You have time. You always have time to wait for an attorney. Tactic 5. The voluntary conversation. The officer insists this is just a casual conversation. You are not under arrest. You can leave anytime. This framing is designed to make you feel safe talking without legal protection. The conversation may be voluntary, but your words are still admissible. Treat every conversation with police as if it is being recorded and will be used in court. Because it may be. Every conversation with police can be used against you. Treat it that way. Here is the chapter I promised you at the start. And this one may genuinely surprise you. The single biggest mistake people make during police questioning is not made by people who are guilty and trying to hide something. It is made by people who are completely innocent. Innocent people talk to police because they believe the truth will protect them. They believe that if they just explain what really happened, clearly, honestly, completely, police will understand. The misunderstanding will be cleared up. They will walk away. This belief is one of the most dangerous legal misconceptions in America. Here is why talking, even when you are completely innocent, can destroy you. Memory is imperfect. Under stress, people misremember details. They get times wrong. They get locations wrong. They forget things they said or did. When police compare your statement to other evidence, security footage, phone records, witness accounts, even minor inconsistencies look like lies, and lies look like guilt. Statements made to police can be taken out of context. Something you say in a moment of stress, phrased awkwardly, explained poorly, can be documented and presented in court in a way that makes you look culpable even when you are not. You do not know what police already know. When you speak to police, you are having a conversation where one side has all the information and one side has almost none. You do not know what evidence exists. You do not know what witnesses said. You do not know the full picture of what police are investigating. You are operating completely blind.
Your attorney knows how to navigate all of this. You do not. And that is not an insult. It is simply the reality of legal expertise.
Professor James Duane of Regent University School of Law, one of the most cited legal scholars on this topic, has stated publicly and on record that he would never speak to police without an attorney present, not because he has done anything wrong, but because he understands the law well enough to know that no good outcome comes from it. If one of America's leading legal scholars would not do it, neither should you. The right to remain silent exists for a reason. Use it. Let us bring everything together. The Fifth Amendment gives you the absolute right to remain silent during police questioning. No one can legally force you to speak against yourself. You are required to identify yourself in most states during a lawful stop. Beyond that, you are not required to answer any other questions. To be legally protected, you must say the words. Clearly state, I am invoking my Fifth Amendment right to remain silent. I want an attorney. Once you invoke your right to counsel, all police questioning must stop. Police are legally allowed to lie to you during questioning. They are trained in psychological tactics designed to make you talk. Knowing those tactics makes you resistant to them. And the most dangerous person in a police questioning situation is not the guilty person trying to hide something. It is the innocent person who believes that talking will help them. It will not. Silence and an attorney will. This is the final video in Phase 1 of the Rights and Reality USA Criminal Rights Authority series. Over the past 10 videos we have covered what to do when police pull you over, Miranda rights, what happens after an arrest, digital privacy rights, the right to show ID, vehicle searches, probable cause, search warrants, police entry into your home, and now, police questioning. You now have a complete picture of your criminal rights as an American citizen. If these videos have helped you, please subscribe right now and turn on notifications. We post a new legal rights video every 5 days. In our next video, we begin Phase 2, Tenant and Housing Rights, starting with, can your landlord really do that? Everything renters in the United States need to know about their legal rights. Until then, stay informed, stay protected. And remember, knowing your rights is your right.